The judge says in response, quote, "We're not talking about locations. That's a false issue. We are talking about the issue of retaliation. He was put on furlough with no conditions other than hang around your house and be in your neighborhood, the only condition. And when it came time for the furlough period to end, he was allowed to stay outside without any conditions other than that. All of a sudden, when the Bureau of Prisons understands that Cohen is writing a book and will likely finish before the election time, he is imposed with conditions. The probation officer doesn't give him a form, the form for home confinement that typically is used by probation. The judge says, quote, "What purpose would there be in a paragraph 1 of this agreement preventing engagement with the media, TV, print, film, books, prohibiting social media platforms, no posting on social media, communications with friends, not to do certain things about publication?" The prosecutor says in response, quote, "The probation officer is just trying. He never drafted an agreement like this." The judge, "I have never seen such a clause. In 21 years of being a judge and sentencing people and looking at the terms and conditions of supervised release, I have never seen such a clause. Have you, Ms. Rovner, ever seen such a clause?" Ms. Rovner, the prosecutor, quote, "I have never seen a federal location monitoring agreement, Your Honor." The judge, "Why would the probation officer ask for something like this unless there was a purpose to it? Unless there was a retaliatory purpose saying, you toe the line about giving up your First Amendment rights or we will send you to jail. We are not going to negotiate about it because if you negotiate, we're going to send you to jail and call you intransigent. How can I take any other inference other than it was retaliatory?" The prosecutor, Ms. Rovner, "The officer had no knowledge about Mr. Cohen's book." The judge, "It's impossible to take that inference." And then, new character in the scene, Mr. McKay, who is a different prosecutor, gets into the mix here. "Your Honor, this is Thomas McKay. Can I just jump in with a factual point on the timeline?" The judge, "Mr. McKay, is Ms. Rovner not capable of answering my questions?" Mr. McKay, "She certainly is, Your Honor." The judge, "You will keep quiet. And if Ms. Rovner wants to consult you, she may. One person speaks on a side." The judge then says, quote, "There is no purpose that I can discern from this paragraph 1. That I can find in any term or condition of a supervised release that I have seen in 21 years of being a judge. Nor is it feasible to believe that the probation officer wasn't asking for something like this because he had some instruction about something like this. I cannot believe fairly that there was not a purpose in paragraph 1 of the location monitoring agreement to stop his exercise of his First Amendment rights. And that's my finding." Okay, and then there's a long discussion about COVID protocols at Otisville and whether Michael Cohen has been quarantined adequately for COVID purposes and whether solitary confinement counts as quarantine. And then we get down to brass tacks. The judge, "Let him be tested tomorrow morning. Ms. Rovner, let him be tested tomorrow morning, and he should be released by 2 p.m. Ms. Perry," he then turns to Cohen's defense attorney. "Ms. Perry, tell me, who's going to be the custodian? Will his wife be the custodian?" Ms. Perry, "Yes, Your Honor." Judge, "Does she need to sign anything satisfactory to the probation office?" Ms. Perry, the lawyer for Michael Cohen, "I don't believe so, Your Honor, but she's certainly more than willing to." The judge, "And she will be taking care of shopping and everything else?" Mr. Cohen will be confined to his home except subject to conditions stated in the agreement? Ms. Perry, the lawyer for Michael Cohen, "Yes, Your Honor." The judge, "I think we have it. I make the finding that the purpose of transferring Mr. Cohen from furlough and home confinement to jail was retaliatory. And it's retaliatory because of his desire to exercise his First Amendment rights to publish a book and to discuss anything about the book or anything else he wants on social media and with others. That is my essential finding. And the injunction is against continuing retaliation against Mr. Cohen by keeping him in jail when he should be confined, as he was before the retaliation, at home." The judge says, quote, "I will issue a written decision further explaining my reasoning, but this decision is a final decision." So the judge ruling orally in this hearing today, for which we got the transcript. We're not allowed to take recordings or play recordings of it, but getting the transcript means I can tell you exactly what happened. And the judge giving that oral ruling, telling the Trump administration that they need to let Michael Cohen out of prison tomorrow, because the judge has concluded that they only put him back in prison to try to stop him from writing a book criticizing the president, to retaliate against him for the work he's already done on this book criticizing the president. And that's not a thing you can do in this country.